This is Jonathan Lipson with The Real Deal on Contracts. Today we'll continue our discussion about the social control of contract and turn our attention to problems of interpretation. How do we understand what the language of the contract means? And more specifically, what is sometimes thought of as the duty to read. This means that if you have signed a contract, courts will presume that you have read it, that you have understood it, and that you have agreed to be bound by it, even if, of course, you didn't read it and perhaps didn't understand it. We'll talk briefly about four things. Number one, how do courts decide what the language of a contract means? Answer objectively. Number two, what happens if there's no signature on the contract? Number three, what do courts do if they are concerned that the language of the contract might be ambiguous? And finally, we'll talk about a couple of key difficulties in interpretation that arise in the modern world. Okay, first, how do courts interpret the language of a contract? Well, the answer is that they ordinarily do so according to the intentions of the parties as expressed in the objective language of the contract. So we care what the parties meant, we care what they intended, but we typically don't look to subjective interpretations. Instead, we look to objective interpretations. The court in the McCutcheon case, I think, has a pretty good standard statement of this. They say that assuming that the contract is properly formed and is enforceable, then, quote, it is the clear law that where there is a signed writing into which the terms of any agreement are reduced, the terms are to be regulated by that writing. And though one of the parties may not have read the writing yet, in general, he is bound to the other by those terms. Right? If we think about things like the interest in predictability in contracts, the expectation interest more generally, understanding how to interpret the words of the contract and sort of starting from the idea that we interpret those words objectively, but reflecting the intentions of the parties, ends up being, I think, an important insight into how the whole thing works. Number two, what if there is no signature? You have a writing. Parties clearly intended there to be a contract, and they intended to use lots of language to describe their obligations to one another, but one or more parties didn't sign. This happens to be the case in McCutcheon, for example. The answer is that at least some of the terms may not be binding, but that then, of course, leads to the question, well, which are and which aren't, and what standard will a court use to decide? The McCutcheon case suggests that courts are concerned about reasonable terms, what folks ordinarily would expect, but that obviously can leave much to the imagination and to the discretion of judges. Number three, what about ambiguity? What if there is something ambiguous in the language of the contract? This in turn raises two subsidiary issues. First, what constitutes an ambiguity? We'll discuss this more in class. And number two, what are courts supposed to do about it if they find one? Well, it turns out that courts over the years have developed many interpretive canons, which are simply standards or techniques that they use to resolve ambiguities in contracts. One is sometimes thought of as construction against the drafter. We construe the terms of the contract in a way that favors the party that didn't have the chance to write the language, but has nevertheless perhaps signed and agreed to it. This, in theory, forces the drafter to, really account for the interests of the non-drafting party. I think probably a somewhat more common and plausible approach involves what's sometimes known as parole or extrinsic evidence. Parole is law French for oral, and it means looking for evidence outside of the literal four corners of the signed agreement. Parole evidence can include things like statements or conduct of the parties. It can include things like dealings of the parties in the past, and it can even include things like conduct in the industry, course of conduct in the industry generally. We'll talk more about parole evidence in future units, in particular involving warranties. But you should understand that parole evidence and problems of ambiguity in contracts are difficult, but often quite common. Number four, some common key difficulties in the modern world. Well, One of the classic things that I think people have to worry about is the situation where terms in a contract are not fully disclosed at the time the contract was signed. Sometimes these are called pay now, terms later contracts, or PNTL. And some courts say, well, terms later just aren't binding. For example, the Court of McCutcheon says you cannot have a contract subject to uncommunicated conditions, the terms of which are known only to one side. On the other hand, right, in the real world, many terms in contracts are not readily available to the parties at the time of signing. For example, insurance contracts are not necessarily available at the time of signing. Many online agreements, when you say, I agree, you click, you may or may not have ready access to the terms to which you are agreeing. A related question is, well, what if the terms are disclosed in some way, but they're just not realistically readable, right? Who really reads 55 pages of the Apple iTunes user agreement before they click I agree? The answer is, unless you live in South Park, the answer is not many folks. That's the real deal on the duty to read and some basics on interpretation. We'll discuss more of this in class.